So today I'm talking to Mr. Andrew Khoo, who is a well-known lawyer. Andrew is the co-chair of the Malaysian Bar Council's Constitutional Law Committee, and he's one of the very few lawyers who know Sabah and Sarawak quite well because, as I understand it, he actually visits Sabah and Sarawak quite regularly. So Andrew, thank you very much for having a quick chat with me. This afternoon, I want to talk to you from a Peninsula Malaysia perspective, basically on the issue of the Malaysia Agreement. As you're aware, right, the Malaysia Agreement now is seen as a very hot political topic, especially in the last 10 years in Sabah and Sarawak. There are all sorts of talking about that Sabah and Sarawak has suffered in terms of federal-state relationship since independence, and there's a group of people in Sabah and Sarawak who talk about legal remedies. One of the things they talk about is, of course, that the Malaysia Agreement is an international agreement, and that perhaps the legal remedy should be via the international arena or under international law. Can I get your comments on whether this is possible? Is it possible to litigate issues relating to the Malaysia Act and the Malaysia Agreement under international law?
Um, uh, James, thank you for having me, and I'm happy to see you and to chat with you. My view is that it will be quite difficult to launch any action based on the Malaysia Agreement. And I say this for several reasons. One of which is, this may be a hot debatable point, is the fact that in terms, at least of the letter of the law and the legal provisions of the Malaysia Agreement, it is difficult to see where the failings are or where the shortcomings are in terms of the legal perspective. I mean, I've looked at the Constitution, I've read the Malaysia Agreement, and many of the provisions that were meant to protect the interests of Sabah and Sarawak, from a legal perspective, is there. It has been included, and it has been respected in, at least in the letter of the law. I think, and we'll come back to it, no doubt, I think a lot of it has to do with implementation and with policies and with personalities. So that's one aspect of it. The other aspect, of course, is the fact that you have to look at who are the parties to the agreement. Even if you were to want to sue, then you've got to say, well, who actually has locus standi, legal position to be able to sue the on the agreement. I mean, the parties to the agreement were the UK government, the government of the Federation of Malaya, and there were representatives from Singapore, Sabah, and Sarawak that signed the agreement, right? But it's very clear from the face of the agreement that the status of Sabah, Sarawak, and Singapore at that point in time were as colonies of the UK. So one would have to, try to suggest that somehow the colonies still were able or have a legal personality in which to sue. And I think that could be troubling to a certain extent. Because I think there would be some difficulty there. I mean, the UK very clearly said, in a sense, that they were, the parties there were the colonies, and they were still the colonial power. So I think to a certain extent, the signing of representatives was to show the consent of the people of these territories. But I think legally speaking, the two real parties to that agreement were the government of the United Kingdom and the government of the Federation of Malaya. So, in order to sue, if you can make a case that you are one of the parties to the agreement and have a right to sue, that could be one avenue. But I'd say that that's difficult. So the other avenue is to persuade the UK government to sue. And as we can see from the I suppose the Hong Kong situation would be the most relevant, right? I mean, people are asking, the British to take the government of China to court over, some of the guarantees that were made that are being so-called flouted by the mainland China government in relation to the rights of the people of Hong Kong. And even Britain is, hedging its bets. It's not really persuaded that it could do that. What they seem to have taken is more a moral approach to say that you must honor the agreement. This goes against the spirit of the agreement. They're using words like that. But I think even if you were to persuade the UK that it's something that it could look at, again, it would turn around and look at the way that the Malaysia Agreement has been implemented and say, well, has there been a legal breach of any of the terms of the Malaysia Agreement? And again, I would repeat what I said. I think it would be difficult to find any real or substantive breach of the letter of the agreement itself.
If the international legal remedy is not possible, what about under the domestic law? Is it possible to sue Putrajaya over elements in the so-called safeguards? So for example, as you know, people in Sabah previously, they did try to sue Putrajaya over the issue of modernization. And also there was an attempt to sue Putrajaya over the issue of appointment of judicial commissioners. Both cases, of course, was knocked out very, very early. So if is there an avenue for legal remedy in the domestic area? I'm also working on the assumption, being a non-lawyer, that if there is, this thing has to go straight to the federal court, right? Because it's a constitutional issue.
Yeah, I mean, so you would file it in the High Court, first of all, and then the High Court judge would have to certify that these involve questions of the Constitution, and then you'll take advantage of the provisions to directly refer the matter to the federal court, and ultimately it would be heard there. But again, the question is, what is the harm? What is the harm that is allegedly being suffered? And if these can be identified, then also the question is this the best avenue? Is this the best forum in which to resolve these issues? And my gut feel is that the courts will say that these are issues in the political realm, and the courts do not interfere, the courts are not the most appropriate forum for these disputes to be played out. And the best would be, with the democratic system of government, and with, I suppose, at the end of the day, elections.
Well, let's just talk about a scenario. So, for example, it's obvious that the big difference between Sabah and Sarawak is that in Sabah, a lot of people are very unhappy about the PTI issue, or the illegal migrants. Is it possible, for example, to link this to the federal government that says that, the federal government promised to look after the security of Sabah once they're in Malaysia, and in fact, rather than looking after the security of Sabah, they allowed a large group of people coming from southern Philippines and Indonesia to enter Sabah? Is it possible to litigate something like that? If it is, how would you frame the question so that it becomes a constitutional issue?
Well, I think, first of all, I would venture to suggest that it can be a constitutional issue even without invoking the provisions of the Malaysia Agreement. Because at the end of the day, the Constitution says that the issues of nationality and things like that are with the federal government. Of course, there are certain protections for Sabah and Sarawak, but ultimately the principal responsibility is with the federal government. And so the question is, in respect of all these individuals who have gained citizenship, right, was the correct process followed? Were they legitimately entitled to become citizens? What is the process that was undergone by these people? And can we open up for review of some of these grants of citizenship? I mean, it's very interesting. Earlier on, I was reading related, but let me tell you anyway. So in Kuala Lumpur, the city of Kuala Lumpur, the Kuala Lumpur City Hall, Dewan Bandaraya Kuala Lumpur, has just announced that there will be certain types of industries or commercial activity that will no longer be allowed to be undertaken by foreigners or foreign-owned companies. So a lot of the small traders and things like that, which in the past, maybe the Muslim migrants or whatever have started undertaking, they'll all, I think, be closed down. So, they will be barred from participating. And even certain areas, certain physical parts of Kuala Lumpur, they will not be allowed to operate in. And the key thing that they said they will review all the applications in the past. So they will look at even though you've been granted a business license in the past, they will review those business licenses to ensure that the new policy will be implemented. So I suspect that a lot of business licenses will now be cancelled because when they review, they'll say, "Oh, this is a foreigner, cannot," and things like that. So I mean, that will in itself give rise to some litigation because you have vested interests, invested rights, and things like that. So I'm just wondering whether there can be a policy of relooking some grants of these citizenships, and whether or not people can look at it and say, "Look, we don't actually see the factual or legal basis why this person was given citizenship," and then to review and possibly even revoke some of those citizenships. So I think if a case can be made, I think it might be better, stronger perhaps, to sort of say, well, this is a breach of the exercise of that responsibility, the legal responsibility in terms of the granting of citizenship to these people. So whether or not the people of Sabah were somehow affected or disenfranchised or negatively affected by the grant of citizenship, it is still a failing of a primary obligation of the federal government that in granting the citizenship to this group of people, there was mala fides, bad faith, or there was corruption or whatever. I think that could be one way of framing it without even having to resort to the special
Malaysia agreement,
protections
yes, and the safeguards.
Yeah.
Yeah.
Yes.
Another question is that, as you know, people in Sabah and Sarawak are very unhappy. This thing is not directly related to MA63, but because, as you know, in Sabah and Sarawak, people mix up all the issues. And one of the issues they're very unhappy about, they put it under this basket called Sabah Sarawak Autonomy and Sabah Sarawak Rights. It's this issue of oil and gas resources. So there are many people in Sabah and Sarawak unhappy with PDA 74. Now, if I were to ask you to wear your legal hat, if you want to litigate this and say that PDA is actually illegal, are there enough legal grounds to litigate and say PDA is illegal because the chief ministers of Sabah and Sarawak do not have the authority to sign, or the whole PDA is illegal because it was passed during era emergency?
I think that certainly there are questions about the Petroleum Development Act. I mean, one of the things that I spotted some time ago in advising one of the now currently opposition MPs was the fact that there's no public disclosure of the accounts of Petronas. It's only disclosed to the Prime Minister. And how can that be? Even if you have a provision in an Act of Parliament that says that that is the case, surely that has to be challenged from the position of transparency, accountability, and why is a particular company given this special treatment. So, things like Article 8 even, in terms of equality before the law and equal protection of the law. I mean, you could well challenge some of the provisions of the PDA. I think in terms of emergency legislation, I think we are clear that there have been cases in the past where there's been an attempt to try and declare certain acts of parliament unlawful because they were passed during the time of emergency, and most of them have failed. So I don't think that is the way to go for it. I think what you can do is take up the point about this affects the rights and interests of Sabah and Sarawak, and there was in the Malaysia Agreement provisions that whenever the rights and interests of the people of Sabah and Sarawak are affected, then the heads of government of Sabah and Sarawak need to be consulted. So I think that part, there is clearly a breach. And maybe that is one of the reasons that you could rely on. Whether that is enough of a reason or whether you need more, I think that remains, of course, the debatable issue. And that's how lawyers make money, because some people will say yes, some people will say no, and you go to court and you see which side has a better lawyer.
Sure. I mean, one of the issues we have, or one of the reasons why it's very difficult to talk about this case legally, is because there's no case law. Nobody has successfully gone and litigate on a major portion on the safeguards Sabah and Sarawak has. Have you heard of a thing called the Chagos case?
Sorry, James, you just broke up there for a
Sorry,
short while.
I said, have you heard of a thing called the Chagos case?
Yes.
Oh, you have, right. Now, there are some
Yes.
activists in Sabah and Sarawak who claim that the Chagos case can be used as an example of how international law is used to make Britain accountable for what they did during the colonial times. Do you think that the Chagos case can be used for the status of Sabah and Sarawak?
I think the short answer is no. I think the reason for that is you are trying to hold a former colonial power responsible for what has happened subsequent to subsequent to the cessation of its colonial authority, right? So somehow you are saying that Britain should have been able to do something to protect the people of Sabah and Sarawak from a breach of the agreement by the Federation of Malaya, and therefore the fact that it didn't meant that it's somehow responsible. Again, to me, one of the reasons why it won't work is because Sabah and Sarawak have their own state elections, right? So they have a way in which to bring about change. And the fact that they have not done so means that, or could mean, could be used to argue that, what Britain left behind was a system of democracy where people were entitled to make their own democratic decisions through elections. And Sabah and Sarawak, and indeed Malaysia, we've gone through 14 now elections over the years, and there has been no impairment to the elections, generally speaking. And the fact is that the people of Sabah and Sarawak have voted in a particular way, and their governments have not really pursued this matter, right? So, there is a section of law when it comes to personal injury called Novus Actus Interveniens, that some new act has come into place that has basically broken the chain of causation, right? So, applying that kind of thinking to this particular situation, argue that there has been intervening factors, players have come into the scene, and it is no longer responsible, cannot be held responsible for what is now going on in Malaysia, and specifically in relation to Sabah and Sarawak.
Okay, one final question. Time is catching up. A quick one. What is your best guess in terms of the legal fraternity in Malaya? Are people interested in MA63, or they think it's something purely to do with Sabah and Sarawak? Even if they're interested, do you think there is sympathy for how the people of Sabah and Sarawak feels?
I think generally speaking, no. I think generally speaking, broadly speaking, I think most peninsula-based lawyers will say that this is something that is perhaps unique to Sabah and Sarawak. Many of them perhaps not understand, and maybe some of that explanation for why they don't think it will work is attributable to ignorance. But there will be some others who say that, well, again, as I have already mentioned, there have been successive elections in Sabah and Sarawak, right? And if the people of Sabah and Sarawak really were burning for change, it ought to have led to a different outcome in the elections. And so the fact that they, overall, the people of Sabah and Sarawak have returned the same government or government that pursuing similar policies, goes to show that while there are people who are unhappy with that situation, they do not represent the majority of the people of Sabah and Sarawak. And so while it's maybe a significant minority, it's insufficient in terms of numbers to change things, and there is not sufficient political will across the board for these things to happen.
Yes.
So I think that will be a bit of a challenge.
Sure. I've noticed that you use the word political will. Is it your opinion that issues dealing with the unhappiness over MA63 and related issues about federal-state relationship, most of this is probably best served by a political way to resolve it, and that the legal route should really not be used at the present time? Or in other words, is
Well,
this mostly a political issue rather than a legal issue?
Well, James, you've actually already asked. If it were to go to court, right? What would the court say? And my thinking is that the courts would say that this is more of a political issue rather than a legal one, and therefore the courts would not be the best arena, best forum to resolve this. So that being said, to me, it is very much a political argument, a political issue, and there needs to be a political solution to this. And the question is whether or not there is enough political will to resolve this. So whether or not the people of Sabah and Sarawak can play off one part of the federation government against the federation opposition, so that whoever needs the support of the people of Sabah and Sarawak, will champion their cause. But then, that's been done so many times before, and sad to say, the people of Sabah and Sarawak have been played out by peninsula-based politicians, but not without the connivance of Sabah and Sarawak-based politicians. So, as much as you want to blame the peninsula-based politicians, and I'm sure there's enough blame to be
Go
to
around.
be put, yeah, but there's enough blame to go around as well, and I think the people of Sabah and Sarawak really need to look to their own politicians, their own leadership, their own democratic system, and ask the question: why is it that we are not able to bring about a government that reflects this political desires on their part? If and I won't deny that this could be the will of the majority, but the will of the majority is being denied by the minority. I mean, same thing with all of Malaysia as a whole, right? We had a government, we elected a government with a majority vote, and now we have, in effect, a government that we didn't vote for, right? So, Sabah and Sarawak people may realize that, hey, welcome to the reality, our world. We've so many times gone to the polls, and we've got a government that we didn't elect or we didn't want, and so there has to be a way in which we, the people, have to bring about the political change that we require, and that may involve a change in the system, or at least ways to circumvent the inbuilt advantage that our current system has for incumbent governments.
All right, Andrew. Well, thank you very much for taking the time to speak to me. I'm sure we'll speak again, but thank you for sharing your thoughts with me. I'm sure people watching this, will realize that nothing is black and white. There's actually a lot of issues which when you take it to a very serious level, other things come into play as well. It's not just a simple thing of just taking the federal government and taking them to court. Thank you, Andrew.
Thank you for having